If we say in paragraph 20 that Cook was employed by Bamley, I'm just making a rough example. In your judgment, you say, you allege that Cook was employed by Nomura. Then it's an egregious mistake, which shows a lack of awareness of the pleading, which we say is an error of law, because we are entitled to have a dispute adjudicated properly. But if we say, well, you've said that one of the factors I take into account is the frequency of participation. I think 1 as opposed to 30 is insufficient. Yes, then I accept that that might fall under S versus Busak.
Well, as you and I probably understand the rules relating to exceptions, we borrowed same from the High Court rules and as in the Competition Act. Does the rule in the High Court deals with plausible evidence? And was the CAC correct in its finding that the tribunal had, or the commission had to lead plausible evidence?
No, it was wrong, because throughout it's actually talking about evidence. It's not talking about facta probanda, the pleading itself, which is what is required right now. And one of the problems, this is what I suppose Justice Rogers was coming to around the correct standard. One of the problems with this case is that we raise a pleading. Inside of the banks answering the facts, they bring their own application with new facts that have nothing to do with what is pleaded. Then the tribunal says, look, this is intolerable. We're going to treat this as an exception. In an exception, no new facts. And this is not a case about evidence. It's everyone accepting that if what is contained in the commission's referral is proved at trial, does it disclose an action or not? Now, if you misunderstand that question, that's an error of law, which you would be entitled to intervene.
Would that not fall within the sui generis approach of the Competition Appeal Court? That you could, in the course of adjudicating such disputes, look at the additional evidence or the new evidence? Would that not fall within their remit?
No, they wouldn't have the power to do that. It's the tribunal that would have the power to decide whether additional evidence is required or not. What it decided in this case, it decided that all of these applications to dismiss will be treated as exceptions, which meant that no extraneous evidence. And one of the problems with the judgment is that it actually doesn't engage that reasoning of the tribunal, whereas it was one of the points we raised, which we still take even now.
Can I just share with you my difficulty?
Of course.
As I was preparing.
I hope I can help.
Yeah, as